Hello friends, welcome back to my channel. Today in this video I will be discussing remedies for breach of contract under the law of contracts. So let's start. The word breach means an act of breaking or failing to observe a law, an agreement or code of conduct. So when we are talking about breach of contract, it means when any of the parties fails or refuses to perform his or her promise under a contract. That is, the party refuses to perform his part of the obligation under the contract. Hence, when one party to a legally binding agreement fails to deliver according to the terms of the agreement, it is called a breach of contract. So, when we say breach of contract, it means one of the parties to a contract has failed or refused to perform his or their part of the obligations under that particular contract. Now, what happens when a party commits a breach of contract? Or we can say, what are the remedies available to a person for a breach of contract? When a breach of contract occurs, the non-breaching party may be excused from delivering or discharging or completing his or their part of the obligation under the contract. That is, the non-breaching party is excused, or we can say is relieved from performing his or their contractual obligations under that particular contract that has been breached by the other party. The non-breaching party may also file a lawsuit against the other party, that is the party who breaks the contract or who commits the breach of the contract, and may also claim compensation from the party committing the breach. Now, when we are talking about the remedies available for a breach of contract, we can categorize them into three remedies. The first is damages, the second is quantum merit, and the third is specific performance and injunction. So, let us discuss these remedies one by one. Coming to the first remedy for breach of contract, that is damages. Remedy by way of damages is the most common remedy available to the injured party, that is the non-breaching party. This remedy entitles the injured party to receive compensation or to recover compensation for any loss suffered by him due to the breach of contract committed by the other party. Sections 73 to 75 of the Indian Contract Act 1872 provides for remedy by way of damages. Section 73. Section 73 reads like this: when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. So, as per section 73, when a party to a contract commits a breach of the contract, or when a contract has been broken by one party, the other party, the non-breaching party who suffers loss or damage as a result of such breach, is entitled to recover compensation from the party committing the breach. However, the non-breaching party can recover compensation for the breach of contract for any loss suffered by him or her by such breach only if such loss or damage has naturally arisen in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of such contract. So, section 73 says that any person who suffers as a result of a breach of contract can recover compensation from the party committing the breach. Now, coming to section 74 of the Indian Contract Act. Section 74 reads like this: where a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract a reasonable compensation not exceeding the amount so named, or as the case may be, the penalty stipulated for. So, as per section 74, when the parties have mentioned in the agreement the amount of compensation to be paid in the case of breach of such contract, then the injured party is entitled to receive from the party committing the breach the reasonable compensation not exceeding the amount named in the contract. That is, when the parties in the contract have initially mentioned the amount of compensation to be paid at the time of breach of the contract, then the party claiming compensation is entitled to receive only reasonable amount of compensation but not exceeding the amount mentioned in the contract. To be noted that this is the rule regardless of the fact whether the sum agreed to be paid is by way of liquidated damages or penalty. Hence, it means that the amount of compensation, if predetermined by the parties, is the maximum amount which the injured party can receive. That is, when the amount is already mentioned in the contract that such and such amount will be paid in case of breach of the contract, then the party claiming the compensation will receive compensation but not exceeding the amount mentioned in the contract. Also, it is to be noted that mention of a specific amount of compensation does not necessarily entitle the plaintiff to claim that particular sum that has been mentioned in the contract. However, it is the court which decides the actual amount to be paid to the party claiming the compensation. But the court cannot award higher damages than agreed upon. That is, the court will award the damage, but that will not be more than the amount decided by the parties to the contract in that particular contract. Now, let us understand this with the help of an example. This is illustration A under section 74. A contracts with B to pay B rupees 1000 if he fails to pay B rupees 500 on a given day. A fails to pay B rupees 500 on that day. B is entitled to recover from A such compensation not exceeding rupees 1000 as the court considers reasonable. So, as per this illustration, A and B enter into a contract whereby A agrees to pay B rupees 500 on a particular day. The parties further agree that if on that particular day A fails to pay to B rupees 500, then A will further pay rupees 1000 to B as a compensation. Now, what happens is that A fails to pay B rupees 500 as decided under that contract on that particular day. Now, B is entitled to recover from A compensation, but that compensation will not be exceeding rupees 1000. Though that compensation will be decided by the court, like though court will decide how much compensation B will receive from A, but that compensation will not be more than rupees 1000 as it has been earlier decided by the parties under that contract. So, this is compensation for breach of contract where the penalty is stipulated for under the contract. Now, coming to section 75 of the Contract Act. Section 75 reads like this. A person who rightfully resigns a contract is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract. Now, section 75 says that when any party to the contract himself resigns a contract and that contract has been rightfully resigned by him, then he is entitled to receive compensation for any damage that he suffers as a result of the non-fulfillment of the contract. He can claim compensation from the other party to the contract for any damage which he has sustained due to the non-fulfillment of the contract. Now, let us understand this with the help of an example. This is illustration under section 75. A singer contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months. B engages to pay her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theatre and B in consequence resigns the contract. B is entitled to claim compensation for the damage which he had sustained through the non-fulfillment of the contract. Here from this illustration we can see that B has himself resigned the contract which B had signed with A for the performance of certain song in his theatre. So though the contract has been rescinded by B himself, but B is entitled to claim compensation as it is B who has suffered loss as a result of the non-fulfillment of contract by A. So as per section 75, a person who rightfully resigns a contract is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract by the other party. So this section 73 to section 75 talks about remedies by way of damage in case of a breach of a contract. Now the second remedy for breach of contract is quantum merit. When the injured party has performed a part of his obligation under the contract before the breach of contract by the other party, then that injured party is entitled to recover the value of what he has done under that contract. Under this remedy, when one of the parties has performed a part of his obligation under the contract before the commission of the breach by the other party, then that particular person who has performed his part of the obligation or his part of the obligation under the contract is entitled to receive, or we can say is entitled to recover the value of what he has done under that particular contract. So this is called quantum merit. So let us understand this with the help of an example. If A and B have entered into a contract and A, who has already performed a part of the contract, is prevented by B from performing the rest of his obligation under the contract, then A can recover from B reasonable remuneration for whatever he has already done. So here A and B, they have entered into a contract for certain work, and what happens is that A has performed his part of the obligation under the contract. Now B is preventing A from performing the rest of his obligation, the rest of A's obligation under the contract. Now since A has already performed a part of his obligation under the contract and he is being prevented by B from performing his obligations further, then A is entitled to recover from B remuneration for whatever work he has done as part of his obligation under the contract. So this is called quantum merit. Now coming to the third remedy that is available to a non-breaching party is specific performance and injunction. Sometimes what happens is that when a breach of a contract is committed by one party, then the non-breaching party, that is the injured party, may, instead of claiming damages for the loss suffered by him because of that particular breach of contract, may have recourse to alternative remedy, and that is remedy of specific performance of the contract or an injunction restraining the other party from committing further breach of the contract. So a non-breaching party may, instead of recovering damages, may also file a suit for specific performance of the contract by the party committing the breach, or for an injunction to restrain the party committing the breach from committing further breach of the contract. So remedy by way of damages, or remedy by way of quantum merit, or remedy by way of specific performance and injunction are the three kind of remedies available for a party who has suffered as a result of breach of contract by the other party. This was all about remedies for breach of contract under the law of contracts. Thank you for listening, and in my next video I will come up with another important topic from the law of contracts. If you like the content of my videos, please subscribe to my channel and do like and share the videos. Thank you once again.